Yes, Mr. Good afternoon, my lord. I have 4 points arising out of questions and issues that rose during the course of the discussion this morning. First of all, I may have given the wrong impression so far as the chronology is concerned, and I just want to clear this up. So the change to the claim form and the service of the particulars of claim indicate, with the schedules attached, indicating that the claim was made on behalf of the Bonga community. That occurred in April 2018. So the amended claim form was the 4th of April 2018, that's in tab 11. The particulars of claim with the schedules attached was the 10th of April 2018. And there was no time bar point taken at that point. The time bar loomed its head the following year when evidence was served, I think about 12 months after that, so in 2019. So it's not the case that those changes were made to address a time bar problem. It wasn't brought as a representative action to address a time bar problem. The second point...
The change to the claim form, that was before service, was it?
Yes.
So it didn't need permission?
Well, that was what was thought at the time.
Right.
But it turns out it did need permission.
Oh.
And that's what the part of the time bar part of the judgment, of the first judgment, is all concerned with. But those acting at the time, again, not myself or my team, but they did it without permission, and it was held that was wrong. They should have had permission, and whether they got permission was dependent upon when they suffered the damage, and hence the very strange sort of split order that was made on the jurisdiction issue. That we won on jurisdiction insofar as we were in time, we lost on jurisdiction insofar as we were out of time, and all of that would depend on the date of damage pleading, which would be subsequently determined.
And the original date of the claim form was December 2017.
Yes, the 13th of December.
13th of December.
And in fact, there is a chronology in the bundles which has all these dates, but that is tab 7 of the first volume of the core bundle.
Yes. Just to follow the story through, I've got, obviously, behind tab 11 in the core bundle, I've got the claim form.
Yes.
That was the one that you just told us about that was amended.
Yes.
And I think the amendment for...
And the original one is at tab 10, just in front.
Oh, thank you very much. Sorry, I was
so what was
trying
added?
to deduct what was in it.
Well, what was added, for example, in there were the words "for themselves and on behalf of the Bonga community."
Yes.
And then that was also evident from the particulars of claim at 165, just 2 pages further on, paragraph 4 and footnote 1. So that was done, as I say, on the 4th and the 11th of April 2018. Time bar issues were raised by our opponents. At that stage, it was all about fight about jurisdiction, and time bar issues were raised by our opponents about a year later. Now, the second point, and an even more important point, that I should have made when Lord Justice Coulson was asking me questions about what was the utility of the representative action and why was it in the interests of justice and the overriding objective for there to be a representative action. And there's a really important point here which I have failed to make clearly this morning. I drew your attention to the fact that Mr. Jalla says that of the affected land, the majority is owned by communities. So the majority of the land is the land where the communities wish to bring a claim in respect of community interests. And I took you to that passage in the transcript. What I didn't make clear is that that aspect of the claim has to be a representative action. And it is still a representative action, even in Jalla 2, so far as the community interests are concerned. And the reason for that is that the communities do not have legal personality. So,
yeah.
so
Mr.
far as...
Jalla is a representative of a representative.
Well, he's a representative of the community which has those rights. Yes. And now that claim, because the community can't bring it in its own name, doesn't have personality, has to be brought by way of a representative action. And that is the claim, in respect, Mr. Jalla tells us, of the majority of the affected land and property. And that is a key feature which I should have, when Justice Coulson was pressing me as to what is it that...
Asking you politely, I think you...
No, well, whatever. I mean, when you asked me more than once politely, but,
yeah.
And I didn't answer what I should have answered, which is, no, it's very important. It's essential that the community aspect of the claim, which is the majority of the affected land, can only be brought as a representative action.
So the 437, whatever it is, communities, you say that has to be a representative action anyway?
Yes, yes. And Mr. Jalla's evidence at paragraph 25 of his sixth witness statement, which took you to the last sentence there, was that the majority of the affected land was community land.
Yes, and the map would demonstrate that.
Well, there isn't a map that demonstrates that at the moment. There are various maps. We can get you better copies of the maps that are in the bundles. But this is one respect in which it's very much not like Belgium or the UK in finding a map, I'm afraid, of these areas, these sort of swampy, mangrovey delta areas. But so that is a really important point as to why their claim in respect of the community rights can only be brought as a representative action. And so I was wrong if I gave you the impression this morning that it's only really for time bar reasons at this point. If you hold that the community's claim cannot be brought as a representative action, then that would mean that the representative claim that's been brought in the Jalla 2 proceedings would it? Well, it might do. Depends on how you phrase it. But
I mean, it's one thing to say that an unincorporated association or an unincorporated community has to bring a representative action. It's another to say that a representative can be a representative of another entity which itself needs a representative. I mean, it's like being a sub-agent. It's not. Anyway,
I see that. But so that was
Sorry, does this flow from? This flows from Mr. Jalla's statement, paragraph 25, where he talks about the ownership of land being in the community.
Yeah.
What's meant? I mean, I'm just trying to find the reference. What is meant by ownership?
Well,
because there's a combination of individual ownership and community-based ownership. I mean, if the land is owned by the community, when Mr. Jalla represents the community, it's sort of both representing a representative, but representing the owner. It's not quite a sub-representative relationship. But what's meant by ownership of the land by the community?
Well,
because that's a deep question of Nigerian law.
Well, it is a question of Nigerian law, and it's not even Nigerian law, which is English law by incorporation. It's more the custom and tradition of these areas, I'm afraid, as far as I understand it.
At all events, the starting point is that the land is owned by the community in some way, shape, or form under Nigerian law.
Yes, yes, regarded as community land and community property. And therefore the rights in respect of it have to be exercised on behalf of the community, and we say that they're being exercised by the representative claimants on behalf of those communities.
And in addition to the land, you say there are other community rights which are not dependent on ownership, but for instance you draw attention to the fishing rights.
Yes. The next question was, did I, and if not, why didn't I, draw the judge's attention to a suggested cut-off to deal with the limitation point, a suggested cut-off date for the limitation? And I'm reminded by my learned junior that we did propose a cut-off for limitation, which was the 2nd of March 2014, and that can be found in our skeleton argument below which is in the supplemental bundle at tab 19, page 196, paragraph 250 of our skeleton argument. And I mentioned it also during the course of the hearing, and for that one needs the core bundle, tab 22, page 1094, at lines 12 to 20 on page 131 in the transcript, and lines 17 to 23 on page 132 in the transcript. So the answer is we did propose one before the judge. The date is the 2nd of March 2014, and that would be our position in this court as well.
And how would that work, the date? That's to say, if you suffered damage, we're representing people who suffered damage before that date?
Yes.
If they'd suffered damage on the 1st of February 2014, what's
The answer is that because of the limitation period effect on those who suffered their damage before that date, at which it's those who suffered their damage after that date. That's how the cut-off would work.
They're precluded if they suffer damage after that
Yes.
So they're precluded if they suffered damage after that date. And how's the date calculated?
No, it's the other way around.
date. Before that.
Sorry.
Before that
Before
date.
that.
Yes.
That's right.
Yeah,
Yes.
that was what I noted before. We're representing people who suffered damage before that date.
So in
I
other
think
words,
I may need to come back on this and clarify it further, but we did definitely put forward a
I'm
date.
not quite sure I understand the logic of that. I mean, if, for instance, you were to count back 6 years from the 4th of April 2018, which is when you amended your claim form, you told us, you wouldn't get to
No, the logic
2018,
is
you wouldn't get to 2014.
no. It's not. It's the logic is it's 6 years before the date of the judge's judgment,
Oh, I see.
which is the date from which he gave the contingent permission to appeal in respect of those who've
Permission to appeal.
permission to amend in respect of those who suffered their loss in time.
I think there were 2 dates, weren't there? I seem to remember. Because one depended on when the allegations in relation to the motor vessel Northia were made, and there was an earlier date in relation to the joining of Stasco, from recollection.
I'm not sure about that. We have his.
Do we have the order?
Yes, we do. It's in the supplemental. Yes, tab 15.
Yes. So I was right. Stasco, the relevant date's 4th of April. And then the second date is 2nd March.
Yes.
You've counted 6 years back from that.
Exactly, yes. That's the logic on the basis of which we proposed it in the skeleton.
Right.
I hesitate to intervene, but I'm not sure I understand what my learned friend is suggesting in relation to a cut-off date at the moment. I wonder if he could be kind enough to clarify, so I'll have to deal with this when I get to speak. What exactly is he proposing? 'Cause may have missed it from his scope, I don't recall this being an issue on a specific cut-off date that's being proposed until you said it now.
Yep. Well, let's go back. We'll go back to the skeleton below.
Supplementary bundle, tab 19.
Yes.
Your skeleton is appeals. Well, I was referring to this appeal skeleton. I'm not sure what the point is before your lordship.
No, I was asked this morning whether we made this point about to the learned judge below, and I'm just making the answer is yes, we did. So it's a page SB 191. Sorry,
191.
Okay. Sorry, I can't read my learned junior's writing. 196.
Paragraph 2252, is it?
Should be
250 and 252. Representatives should be limited to claimants whose claims accrued on or after the 2nd of March 2014.
Okay, yeah. 249. That's right.
Yeah.
And 250. Yeah. It explains the date. Same approach can and should be applied in these proceedings, and the named representative capacity should be limited to those other claimants, community claimants, in Schedule 1 or 2, whose claims accrued on or after the 2nd of March 2014.
That's just over 3 years after the spill. Spill December 2011.
Yes, that's right. Yeah. And as I say, that was then followed up by a discussion on the transcript, which I gave you the reference for. And then the last point arising from this morning, Lord Justice Coulson asked for a reference to when we said below we were not pursuing paragraph 1 of the prayer. And that's also in the supplemental skeleton. That's at paragraph 228. And we mentioned that also in the transcript. At page 1088, page 105 of the transcript, lines 21 to 25. Now, just reverting then to...
Just 228. The content to pursue those claims, that's the individualised claims. There's no actual reference to paragraph 1 of the prayer. Certainly not at paragraph 228. But you say that's what it was intended to mean, is that right?
We'll come back to see if there are any further references. That looks like it's a subsequent reference. But I'll move on to just trying to complete the summary of the facts and circumstances. This is a case where the original solicitors on the record at the time of the strikeout hearing had obtained authority on behalf of the listed individuals and the communities. So in that respect, it's very different from the Google case or the Emerald case. And there was evidence before the judge below that the listed individuals all gave specific authority letters, and the communities all gave authority via the relevant community leadership. And the judge made some findings in relation to that, as you will have seen in the judgment. paragraph 78 of the judgment, he made some findings there in the context of discussing the certainty of the class. And about halfway down paragraph 78 on page CB 155, he says, in the present proceedings, the individual and community claimants who were to be represented are listed in the schedules, the amended particulars of claim, and their solicitors asserted that all had given their authority to the lead claimants to act on their behalf. The latter assertion was not accepted by the defendants, but at this stage it would not be possible to hold that it was wrong. So that is a point of difference from some of the other cases where it's been held there isn't a common interest. And so far as whether there might be any conflicts of interest between the class, the judge also made a limited finding at paragraph 69, in the final sentence of paragraph 69 on page CB 153, where, having set out the matters on which we were relying, he says, in this regard, and in relation to these issues, I see no conflict between the claimants that would render the representative proceedings inapplicable or inappropriate. And so the fact that there is, was said to be authority, the point I was on a moment ago, and the fact that there is no conflict between the claimants, puts us in a different type of case from the Emerald case, where those were the two key concerns that Lord Justice Mummery had in that case. That how could people be bound where they haven't given authority for the proceedings? And what would happen if there was a conflict between the direct and the indirect users of the air freight services?
Neither of those points were particularly material in Google. I mean, you have 4.5 million people who hadn't given authorization,
Yeah.
or might not be in conflict. That wasn't an obstacle in that case.
No. It's but it's another matter. I think it was my fourth proposition.
Yes.
That makes it easier to find that there
Yes,
is the
no, I
same
understand.
interest, because they have
Yes.
they have joined together in jointly giving instructions, and no one can perceive that there's a conflict between them.
But your point is it can't be held against it, but insofar as it's relevant, it's a point in your favour.
I think that's a much more eloquent way of putting it. Yes. So bringing those latter points together, we say that there are four elements here. That firstly, that the focus is on one form of relief for damage to property, either an order to clean it up or payment of money to enable it to be cleaned up. And that damage to property does not depend on any individual characteristics of any individuals who might own the property or control the property. And in fact, as Mr. Jalla has said, the majority of the property affected is community property. Second element is that there is a management committee which is set up in anticipation of handling the proceeds of the joint action for the benefit of all. And I've shown you the evidence in relation to that. Thirdly, that all the evidence is that and the judge made a finding that he couldn't say it wasn't correct, that all of the individual claimants and communities had authorized the proceedings to be brought. And fourthly, he made a finding that, as far as he could see in relation to the issues on which we relied, there was no conflict between the claimants which would render the proceedings inapplicable or inappropriate. So we say that in those circumstances, this is a case when one can say that the relief sought is beneficial to all of the claimant cohort. It's not based on the personal circumstances of any individual claimant. It's largely relief for the benefit of the communities where the majority of the damage has occurred. And either the communities and the individuals within them will benefit from the injunctive relief, if that form of order is granted, or if not, they will benefit from the damages and they have agreed amongst themselves how the damages should be handled by the committee. And so we're not relying on individual loss and damage depending on individual circumstances. It's all about where is the property which was affected. And it's regardless.
It's the individual properties. It's not the individuals who own the properties, but it's individual property damage. Because
it is that. I mean,
Antwerp may be spattered.
Yes.
Eep may be
Yes,
swallowed.
yes, it is.
So you're agreed, but you've agreed. You quite accept that that would have to be part of the investigation. You're not seeking to duck that.
No.
But so I understand that this is all to do with the point of principle, but this is an unusual case.
Yes.
In many ways, because as you say, the people have given authority. But it does depend on the individual characteristics of the land in the sense of how the extent to which that land has been damaged by the oil spill.
Yes, but it does depend on the nature of the damage, definitely. But the nature of the damage doesn't depend on who owns it.
No.
That's the point.
Depends on what happened to the particular parcel of land.
Exactly. And that would be the same if there was one landowner, the king, for example, who sued on behalf of everyone living in his territory, as happened in the Akenrunten proceedings. And so
Is those separate, because I've not looked at those, are those separate proceedings also about this oil spill?
I believe they are, yes. I mean, I
only asked that because
yes.
Before I left the TCC, I was case managing another pollution case, which was not this oil spill. And there, the claimant was the king of
yes.
whatever the area was. But I don't think it's the same king.
No.
And so I don't think it's the same.
No, that's not what we're referring to as the Akenrunten proceedings. These were proceedings that were commenced, then discontinued, and I believe they've now been revived. But I'm not acting in those. But they were being case managed at the same time.
Because it relates to the same spill.
Exactly.
Yeah. Okay.
Your point may distinguish the example put to you, my Lord Justice Lewison, before lunch about a train crash, where the damage there may depend upon the particular nature and circumstances of the individual.
Yes.
And there may be no similarity between any one individual because of the nature of the injuries.
Yeah. The similarity would be if the people on the train said they're not suing for anything that's based on their individual characteristics, but they're all suing for their property that was damaged on the train.
Their loss would depend upon the nature of their own individualised injuries. So,
if it was,
I'm just saying your example falls on a different side of the line. I mean, they're not necessarily comparable situations.
No. What we're trying to do, and I think we have succeeded, is to say we're bringing this action for remediation, either the cleanup or the damages to pay for it, for all of the affected property in which is in these communities or is owned by these individuals. But we're not relying on the characteristics of the individuals other than as a means of identifying the property. That's why we say, to come back to the Duke of Bedford's test, before we go to the judgment, we say there is a common interest and a common grievance, and a representative suit is in order because the relief sought is in its nature beneficial to all who the plaintiffs purport to represent. And it's insofar as one focuses on the differences, as the learned judge did, he was falling foul of what Lord Macnaghten said on page 7, which is, in considering whether a representative action is maintainable, you have to consider what is common to the class, not what differentiates the cases of the individual members. And what is common is that they all say that their property was affected by the spill, and that the impact on the environment and the property is shared by all of the listed communities and individuals, and they each say that their damage was caused by the ingress of oil, and they have the same interest in it being cleared up or damages being paid in respect of it. And the scale of the inquiry and of the evidential issues, which obviously can't be underplayed, but that is a function of the geography, not a function of this being a representative action. So, if I may then turn to the judgment. And turning to paragraph 69, where the judge started to apply the principles to the present action.
Just before we go to 69, can I ask you this? Paragraph 60 is an identification of the principle. I don't understand your skeleton to disagree with those principles. I understand this appeal to be about the judge, what you say is the judge's misapplication of the principles to the facts of the case. I mean, I noticed that this summary is currently the summary that's identified in the White Book.
Who is it?
Yeah. Although there is a note that then says permission has been given to deal. But is that right? I mean, I don't understand you to criticise this summary of the principles.
Could I reflect on that? Because I focused on his application of the principles, and there may be some points where we depending on how he's exactly
wording it. Well, if they're
wording
important, I'd assume they would have
it,
loomed by now.
there's nothing that
There's nothing that's jumped out.
strikes me at the moment, but I will, as you've asked, I will focus
about subparagraph 5, last sentence. Where does that come from? Part of the reason I ask that is that the White Book, at paragraph 19.6.3, refers to a case in the High Court of Australia called Carney and Esander Finance, which I had a look at, which does seem to apply precisely the test which the judge says is not sufficient.
Well, I suppose it's my argument would be that the test is still really the Duke of Bedford, which is the common interest, common grievance, and a relief which will be beneficial to all. And therefore, I suppose I don't disagree with that statement as such in the second sentence of paragraph 5.
Yeah. The other point which I thought I'd mention arising out of my homework is that Professor Zuckerman takes a slightly different view of pollution cases in the current edition than in the quotation cited in Emerald. Now, it may be because of the judge's decision in this case, I don't know, but he now seems to take the view that, I think I'm quoting him, a defendant can stymie a pollution action by alleging that the pollution dispersed at different rates.
Yes, well, that might be inspired by what's happened in the present case.
But in fact, that's a distinction without a difference, given your acceptance that we'd have the judge doing the case would have to look at dispersal. You don't get round that because it's a representative action.
No.
In your case.
No, quite.
Which comes back to the question of, why this is a representative action in the first place. But on this point, you say, well, this can be a representative action, and I accept you'll have to look at the question of dispersal of pollution, because that goes to the question of whether the community in the equivalent of Antwerp suffered the same damage as the community in Ypres.
Yeah. Of course, the court still, even though it's a representative action, the court still has available to it all the case management techniques that it would in any case. So it can take a sample or a test case as a way of breaking the back of the case and maybe putting the parties in a position when they can then settle the case, which as often happens in non-representative actions as well. Mm. So it shouldn't be thought that because it's a representative action, everything has to be tried monolithically, to use the judge's phrase. It doesn't. All those case management techniques, test cases and sampling, can be used in a representative action, in my respectful submission.
Which is why this case isn't really about case management, it's about limitation. I mean, it could all be managed one way or another, whether in a GLO, representative action, or just being bashed in the tech court. I mean, I'm not saying it's a good point or a bad point for you.
Well, no, except that the communities cannot be represented, cannot sue other than in a representative capacity. Yeah. And so, which is I didn't stress enough this morning.
Yeah, no,
I should have made. Yes. Yeah. So that aspect, even Jalla too, they are being represented by individuals who live within the communities, who are suing on behalf of the communities. So the communities themselves cannot sue.
You could have a representative action for part of an overall claim. It wasn't that Mud Harbour we looked at, where there was part of the claim was categorised as representative, leaving the rest to do what it would otherwise do.
Yes, there were. In Mill Harbour, there were quite a number of individuals who were named claimants, and I think the representative claimant was number 43 or something like that. And there were representatives as well. Yeah. So I was going to go through paragraphs 69 to 77, basically. And so 69 is where the judge, as it were, addresses our positive case. And there's no doubt the claims do represent common issues of law and fact. Each requires determination of the fact of the Bonga oil spill, how and why it occurred, whether its occurrence was caused by a breach on the part of Stasko or Snepco, any duty owed to the claimants. For the present purposes, I assume without deciding any breach of duty owed to the claimants would have been owed to all. It's obviously desirable.
You agree with this paragraph?
Well, we do. We agree with this, but we say that he rather, as it were, undersells the point. He doesn't. But we would say that the factors that I have outlined are in themselves sufficient to constitute a common interest. And what he doesn't refer to in this section is he doesn't refer to the fact they'd all given authority. He does refer to that in paragraph 78. And he doesn't refer to the fact that the management committee and the way that they had agreed to handle claims inter se. Now that, which was put before him, but does have an impact on whether this is a relief which is for the benefit of all. And that's what makes our case quite close to the EMI and the Independiente cases, where all the members have agreed that any damages recovered on their behalf can be handed over to the British phonographic industry. So we say that so far as that paragraph 69 is concerned, the judge didn't give enough emphasis to the points that I've made, and didn't take into account that they'd all given their authority, and there was the management committee and the central handling of damages, and he should have held that those matters were sufficient in law to satisfy the same interest test of Lord Norton. And instead, what he did is he then focused on not what they had in common, but what differentiated them.
So you say what he said in paragraph 69 was enough,
yes,
to bring yourself within the rule.
Yes.
So in that case, it must follow, I think, that you do challenge the last sentence of paragraph 60, subparagraph 5, where he said precisely the opposite.
Well, Well, it's not just what. So there were a few other things that he didn't say in '69. One is he didn't say that there was the committee who was dealing with the matter. Second, he didn't say that in '69 that they'd all given their authority for the handling of the claims jointly. And thirdly, what he hasn't stressed in '69, but I have stressed, is that it's all the same type of damage. And the claims would be the same even if the property was all owned by one person, which is another argument I made to him. So when I say the factors that I've laid out, all of those factors that I stressed in the last section of my submissions from shortly before the short adjournment until a moment ago, are the factors together with what he has said in '69, which we say is enough. I mean, there must be under the test of Lord Macnaghten, there must be a common interest in the relief. But we say that there is a common interest in the relief because it's relief of the same damage, and they've agreed to handle their claims by the same sister jointly with a management committee. I mean, maybe it won't be the same cleanup in every place, but they've agreed to join together for that purpose of seeking remediation, either by action or by money. And that is common, that is relief, which is a common benefit to all. So, but the judge didn't mention that.
Well, he deals with that in paragraph 71, doesn't he?
He does.
I know you're going to come to it,
yeah.
but that's when he deals with the question of common relief.
Yeah, that's true. So turning then to 70. So what the judge then does is assuming all the findings were made in the claimant's favour, the facts and issues outlined immediately above do not give rise to right of relief because they stop short of landfall or damage to the claimant's interest. So this is where he then starts to consider the relief aspect. Beyond the common issues of fact and law outlined above, these proceedings are individual claims because each claimant, or possibly small group of claimants living in a particular community, in each community needs to go further and prove that Bonga oil caused them damage. Now, we say, well, yes, that's true. The damage needs to be proved. But that doesn't mean that the test for representative action is not met. Clearly, in the tort cases, Prudential, EMI, Independiente, all of that, there had to be proof of the damage. But in those cases, there was nevertheless a representative action. And in Google, all the claimants, it had to be proved for all the claimants that they did not consent. And if the judge's reasoning here was correct to say that you need to go further and prove damage, that would effectively mean that you cannot have a representative action for a mass tort event. And it would mean that EMI and Independiente were wrongly decided. So where they rely, as we do, on damage to property without reliance on personal characteristics, and where it's agreed to come together under the management of a committee to bring these claims, we say that is sufficient to indicate that it's a relief which is the benefit of all. And he makes a similar point in the last sentence. He says, I would go further. It would be necessary for them to show that they have suffered damage to an extent that justifies their claim for remediation relief. And we say, yes, that's true as well. But that, again, it doesn't follow from that they don't have the same interest and they don't meet Lord Macnaghten's test. And we do also rely on the fact that the matter has to be decided from the pleadings, as Lord Macnaghten and his colleagues said in that case, and I gave you the references. the test under 19.61 does not require that the parties have to be in identical positions. They can have the same interests, but aspects of their position may be different. And what it requires is a shared interest in the claim, and we say that is satisfied in the circumstances here. Turning to paragraph 71, he says the defendants made it clear that they would raise substantial objections to the English court granting remediation relief. Leaving those objections on one side, the court did not make an order or orders in the alternative of paying the costs without investigating precisely where such remediation was required and whether it was attributable to the 2011 Bonga oil spill. Again, we don't disagree with that. But that point would be the same if a single person was seeking the same remediation.
Yeah, this is a theme that you return to from time to time, quite a lot of the time. And it's really one of your big points, isn't it? That what you say is the judge lost sight of the fact that the action wasn't made any more complicated by the fact that it's representative, because the same inquiry would have to take place whether there were one owner or 3,000 owners.
Yes, and the same relief would be granted.
Yeah.
So if it would be the same relief if it was one owner, why is that relief not common to all? They're not relying on their individual characteristics for the relief. They're all seeking the same type of relief in respect to the same damage, albeit to different bits of property. So I'm sorry to repeat the point, and maybe it doesn't get better by repeating, but
Well, you say that failure to appreciate that there was very little difference underlies the whole of the reasoning in paragraph 70 onwards.
Yes. Well, yes. I mean, so the way I would, I mean, I can't repeat everything as we go through every paragraph,
No.
but basically I started with my propositions, and then I took you to the facts, and I say when you put those propositions together with the facts, the judge's reasoning doesn't stand. I mean, it's carefully reasoned, but my respect for the situation, it's wrong when you stand back and you look at the law and you look at the facts of this particular case. And so we don't disagree with him saying, yes, you would have to prove that, what he says there. And he says that, then he says, no principle of law has been identified that would enable a claimant or a community at one location in the allegedly affected area to claim remediation for damage suffered by another community at another location. Well, we're not saying that. We're saying, yes, there may well be a patchwork of success. The reason it's a common, it's for the benefit of all, is because they have grouped together with a lead claimant and a management committee, and they have that's how they have chosen to pursue their litigation. If they get damages, the committee will decide how to allocate the money that's been awarded. He says it's a misuse of language to characterize remediation relief that an individual or community seeks as being relief that's beneficial for all. Well, let's come back to the same point. Later, he says in that paragraph, it's possible to imagine a patchwork of success. Well, fine, we don't disagree with that, but what we have to remind ourselves is that this has to be decided off the pleadings. You have to assume that the allegations in the pleadings are true, that these people say that their property has been damaged. You can't have a sort of halfway house where you doubt that they will succeed in their claim. If their claims are correct, do they have a common interest? That's the correct test. That's the correct way of approaching this.
But you would accept, I think you've accepted, that we have to be realistic, which is why you accept there may well be a patchwork of success.
Yes, I do.
Because it must be an inevitability that some land will have been, in that sense, less damaged than other land.
Yes, no, I entirely see that, and that then takes us back to the point: does it cease to be relief? It's for the common benefit of all, because individuals own different bits of land or more pertinently, we're talking about 450 communities, and some communities might succeed and some might fail, where they have grouped together to bring a representative action. Now, then paragraph 72, he says, in principle, and this sentence we say is right, in principle, the existence of individualized claims does not necessarily prevent an order for representative proceedings. We agree with that. But the question, he says, is whether the individualized claims can be regarded as subsidiary to the main issue. That's the subject of the proceedings. Well, first of all, I'm not sure that the authorities put it in that way of saying what is subsidiary. But what the judge then does is to not take account of our case, which is they're all pursuing the same damage, albeit dispersed over a large area, and they've agreed to pursue this claim collectively. And then he quickly, in the 8th line, starts talking about the evidential complexity. Now, we do say that that is clearly wrong. Evidential complexity can't be a reason why they don't have the same interest. They could have the same interest if the matter is very, very complicated evidentially or not. And he talks about 8 lines from the bottom of that paragraph. Although I make no findings of fact, the difficulties of attribution of causation are highlighted. So he's really talking about the difficulties of proof and not deciding the matter off the pleadings and assuming the pleadings are correct, which is how he should do it as a matter of principle, both as discussed in the Duke of Bedford's case and by Mr. Justice Aikenhead in his summary of the principles.
But again, I think it's the same point as before, isn't it? You would accept that at the trial, if this was a representative action, at the trial, however it's done, the claimants would need to show that this spill had caused the need for that remediation damage, whether it's work or the cost of work. I mean, in other words, yes. the alternative yes. cause, this wasn't our spill, it was Texaco's spill or whatever it is. Yes. You accept, I think, that again is something which would have to be considered. That can't be ducked within the trial.
No, not at all. And I say that can be dealt with by normal case management techniques within the confines of a representative action.
And to taking up my Lord's point, that would arise whether it's an individual action or a representative action.
Exactly. But we keep coming back to that. And the one landowner...
But insofar as the judge is focusing upon administrative convenience here, that's relevant insofar as there is no difference between the different types of proceedings. Hard to see why it should be relevant to common interest. It's a neutral fact.
Exactly. Evidential complexity could be evidential complexity in a suit brought by one person, and there might be no evidential complexity in a suit brought by 4 million people. It doesn't tell you whether this has got a common interest or not, evidential complexity on its own. So that's paragraph, and if that is the approach that he has, we say, if he's erected the hurdle of saying you've got to show that the individualized claims are not subsidiary, we say that the authorities don't really support that. The authorities say it's a flexible test in the interest of good case management and the overriding objective. And if it's the case that the majority of the area is community area, and communities can only bring their claims by way of representative proceedings, then it is erecting an obstacle to a representative action to say, well, there's something that's more than subsidiary, and therefore you can't have a representative action. it's focusing on the differences. Go back to Lord McNaughton rather than what is common, the differences between the parties.
But the fact that some claimants would have to bring representative actions doesn't. It's a red herring, isn't it? I mean, if the village cricket club sues on behalf of cricket clubs all over the country, the fact that that particular cricket club couldn't sue for trespass to its own cricket pitch wouldn't tell you anything about whether a representative action was or wasn't suitable.
Well, it would mean that for the damage to that cricket pitch, the proceedings could only be brought by way of a representative action. That's what we're saying. That for the damage to the community interests, the proceedings can only be brought by way of a representative action. They can't be brought in any other way. So,
well, I think that begs the question whether the cricket club in Devon can sue on behalf of a cricket club in Yorkshire.
This is one very, very big cricket pitch, I suppose.
yes, that's certainly. I don't think it's very suitable for cricket, most of this area. Now, the other point that to bear in mind here is that what the judge has forgotten on the authorities is what you need to look at is what the claimants are asserting. The claimants are asserting that they have suffered the damage. If that allegation is true, do they have a common interest? The judge has flipped it round with respect to him and looked at what he calls the defences, and to say that the defences are different. But all the claimants have to prove the same thing, which is damage to property. The defences is really only the other side of the coin. I mean, the defences he's talking about are establishing the defence that it wasn't Bonga oil, or establishing the defence that it happened at a later period of time and therefore, an earlier period of time and therefore limitation has expired. Well, those are not defences that are anything different from what the claimants have to prove if their allegations are correct.
But in any event, I thought you said it doesn't matter because the fact that an action is a representative action does not preclude a defendant from establishing defences against individuals who, whether or not they are the representative or the represented.
Yeah. As Justice Andrew Smith said, insofar as there are separate defences, he said, representative proceedings are sufficiently flexible to accommodate that. And they've always been regarded as flexible. If we go right back to 100 years before Lord McNaughton was writing, he was saying it's always been regarded as a mechanism of convenience for trying something that it needs to be tried, and this is the best way of doing it. So then, paragraph 73. Now, he says one of the oddities of the abandonment of the individualised claims for damages in these proceedings is that it only applies to represented persons, not to Mr. Jalla and Mr. Chuja. Defendants submit that this oddity shows that Mr. Jalla and Mr. Chuja do not have the same interest as those they wish to represent. He said, I wouldn't decide that issue on this basis. So in fact, he doesn't rely on this. But he does say, what it does evidence in my judgment is that the decision to abandon is a procedural expedient which owes little or nothing to the application of the overriding objective. And this is where he's possibly a little unfair to us, because although we accept that it's done in order to meet the same interest test, there's a very good reason why we want to keep alive the representative claims on behalf of the communities and the individuals, and not be subject to further time bar problems. And indeed, the communities can only sue on a representative basis.
Well, that point, which you made a number of times this afternoon, that is not reflected anywhere in the judgment. Nowhere is the point made that the communities can't
Well,
don't have their own legal identity, so would have to be the subject of representative actions. So I don't know, the point may arise as to whether or not that was ever a matter that was canvassed before the judge. I don't know. But
yes.
I haven't been able to find that in the judgment, that point in the judgment.
Yes, no, I'll have to think about that. And then paragraph 74, he says it's obvious that individualised factual and causation defences will be raised into relation to all individual claimants and all communities. But my answer to that is that this is simply the flip side of it having to be proved that there was damage and when it occurred. So this is something that the claimants have to prove. We do accept, of course, that the claimants have to prove loss and damage, but these are not defences which are apart from what the claimants have to prove. And then so far as the last part is concerned, he says it may be safely predicted the defendants would scrutinise the dates on which the damage is alleged to have been suffered, alike with a view to running individualised limitation defences. And we've already addressed limitation and how that can be dealt with separately, in a less draconian way than striking out the proceedings. 75, then he says that hasn't demonstrated common interest, insufficient to lead to the relief that they claim. And we're really back to the same debate that we had in relation to paragraph 69 and 70.
So he's saying there's some, but on his interpretation, you don't get over the line.
Yeah, I mean, I don't think he's really adding a great deal to what he said earlier there. And then this paragraph 76, he draws a distinction which we respectfully submit is not a valid distinction. And because he says in the period to the 19th of September 2019, it might have appeared possible at a stretch to treat the suffering of damage and defences of limitation monolithically, in which case it might have been tempting to formulate the common issues in terms that could give rise to the claimed relief. However, since the claimant's case began to shift on that date, it's become increasingly clear that such an approach wouldn't have been mistaken. So what he's really saying is that up to that time, he understood from the way that the case was being presented that all of the claimants and communities were located on the Atlantic coastline. But after that, it became clear that they were located inland along creeks and waterways in the delta. But the legal nature of the case wasn't any different. They were always bringing tort claims. There's never been a basic change in that. And then really 77...
I took that to be a reference back to the fact that as a result of the presentation, whether it's a shift or what, it meant that it was all going to be much more difficult,
more complicated,
to identify, when the oil first struck the land and so forth. Hence his reference to it not being monolithic.
Yeah,
I take you made submissions about that.
It's the same point as the evidential complexity point.
I think it is.
Yeah. So and then there's really not much. Then 77, he says, "I therefore hold," and we looked at that this morning, and that's the only basis on which he's come to the decision. And we say, for all those reasons I've given you, that was the wrong decision. He should have held that there was a common interest, and should therefore not have struck out the representative part of the proceedings.
Just one more question before you sit down, Mr. Dunning. What, if anything, should we do about Google pending in the Supreme Court?
Well, your Lordship will have a better idea than me. I don't know what we should do about that. because I have no idea how long they will take to produce their
Well,
judgment.
quite. It takes as long
It
as
was-
a piece of string.
And it's not.
But are you urging us to give judgment before we know the results of whatever the Supreme Court decides in Google, or are you urging us to wait until we see what they say about the scope of representative actions? I mean, do you not have any position on it at all?
At the moment, I don't have a position on it, but I can take instructions.
Nobody's written to the court to find out.
No, I don't think. I don't know whether they
There
will
are
tell
rumours
us.
going around, but no one knows how accurate the rumours are. In my head, that it could be relatively soon, but who knows what that means.
The other thing is that it's not just about 19.61. Of course, that case. When one looks at the argument and the cases, there's a lot of argument on other points. So it may be that other points mean that they don't get to 19.6, for example. I don't know. I mean, I haven't looked at the structure of the decision tree. As it were.
No. I mean, it sounds as though you're saying we should produce judgment in our own time and not wait for Google.
Well, that's what I've been assuming, but that's why. But let me think it over, and if necessary, I can let you know tomorrow.
Yes, Lord Coulson.
My lords, I just can take a moment just to put my papers in the right place. I'll take my mask off. My lords, I'll come to that. Just on that last question, so you know what our position is. We don't think that the decision in the Supreme Court can make my learned friend's position any better. The appeal is, of course, not by... The appeal is by... to suggest that it was too narrow a result. When we look at it, we will see that the way that the appeal is presented, and I don't think there's a cross appeal, it can't make his position any better. But let me come to that then, just so that your lordship knows as it's on your lordship's mind about this at the moment.
And I mean, I'm bound to say that was my impression, was that Google in the Court of Appeal, I mean, Mr. Dunning's first ground of appeal against Mr. Justice Stuart-Smith is that this case is materially indistinguishable from Google. So I had assumed Mr. Dunning would be quite happy for us to decide this appeal on the basis of what the Court of Appeal said in Google. And I just wondered if you were of the same mind.
I'm simply, and again we'll consider it overnight, I'm simply working on the basis of, because it has been possible to see what arguments have been advanced in the Supreme Court, I could see that the position could get worse from my learned friend's point of view, but can't get better, depending what the Supreme Court decide. And I'm content for your lordships to decide this matter on the basis of where Google stands in the Court of Appeal. My lords, sorry, let's move this over here so I can get it. Do you inevitably have that result?
At least it wasn't your water going all over the place.
I do that later, my lord. Your lordships have already picked up really the first point I wanted to make, which is this is actually, by my calculation, it's the fifth attempt, certainly the fourth attempt, by the claimants or their legal representatives, or those who purport to be their legal representatives, and I'll make good why I say that, to try to get round the limitation problem that they have. And that's the context in which this arises. And let me just show this a little bit. Of course, your lordships know that chronology, which is at core bundle, page 114, is quite helpful, though it's not, in fact, complete. It's in, I forget which one it's in. Well, it's first core bundle, and it's page 114, and the tab number is 7. Obliged. So the spill took place on the 20th of December 2011, and the proceedings were started on the 13th of December 2017. That is to say, just a couple of 2 or 3 days before the 6th anniversary of the spill. That was described both by Mr. Justice Stuart-Smith in what I'm going to call the March judgment. I'll come to the March judgment. That dealt with the limitation issue before then dealing with the issue in August, which is the appeal that my lords are dealing with. He described it as the proceedings being issued hard up against the limitation period, an expression which my Lord Justice Coulson picked up in the judgment of this court in relation to nuisance. And it's absolutely right. That's in paragraph 34. I think that we'll come to it. What my Lord Justice Coulson said then, perhaps we should just give the reference to it at least. It's the nuisance appeal, and it's at paragraph 14. And the reference to where my lords have that is at Authorities Bundle, tab 4, page 772. And of course, both my lords, Lord Justice Lewison and Lord Justice Coulson, were members of that court. And what I'm sorry, tab 22. I'm using a different version. Tab 22. But the page number is right, page 772. And paragraph 14, which is what I wanted to refer to at this point, is at page 772.
Which bundle am I supposed to be looking at?
Authorities Bundle.
Authorities Bundle 3.
I don't know how many volumes your lordship's got.
3.
You've got 3.
Tab 22, yeah.
Tab 22.
Yeah.
Paragraph, page 776.
That's tab 23 in mine. But,
Yeah, tab 23.
sorry.
Yeah.
Page 76, yeah.
Yeah.
76, yeah.
It's paragraph 14. And my Lord Justice Coulson notes in the second sentence that, as the judge rightly noted at his judgment, paragraph 147, these proceedings were therefore issued hard up against the expiry of the limitation period. The difficulties which the appellants now face and with which this judgment is concerned stem from that fact alone. I'm therefore inclined to agree with Lord Goldsmith when he submitted, on behalf of the respondents, that it's surprising that there is no explanation as to why the appellants waited so long to commence these proceedings. And that remains the fact. There still has been no explanation of why there was such a long delay. And a lot of what's going on derives from that fact. We know this is not a case where, as it were, the incident was not known about, only came to light a lot later, because we know, and my lords can see it from the chronology at page 114, the first page of the chronology I referred to before, which notes that there was, in August 2012, that is to say just 6 or 7 months after the spill, there was a solicitor's letter. In fact, it was sent to 2 shell companies. And so we know that the possibilities were understood. And in fact, we know there was knowledge about the spill and what was said to be the consequences before that date, because in the March judgment, which my lords have in the Authorities Bundle at page 662, and that is tab. So I'm dealing with it by page number rather than by tabs.
I think it's going to be tab 21 in my bundle.
That's helpful.
This is Mr. Justice Stuart-Smith.
Mr. Justice Stewart
yeah.
in March.
Yeah.
We'll come back to the order, how these come about. I just wanted to pick up on one point here. If my lords would go to paragraph 34 of the judgment, Mr. Justice Stuart-Smith's judgment.
Yeah, so he quotes a lot of material from the press.
Collects material about when the existence of actionable damage might have been known, starting with a journalist report as early as the 1st of January 2012, so that's within days of the spill. And it actually includes a comment coming from the chairman of the Nigerian Senate Committee, so quite high-profile issue. And just a couple of points before I just push on to where we go from there. My lords know that actually there is an issue as to whether the relevant limitation period is 6 or 5 years. We say it's 5 years. That can't be decided at this stage. It will be decided as a preliminary issue, as a set of preliminary issues to be determined in March, February next year. February next year. We'll come back to that in the order made by Mrs. Justice O'Farrell. So that's one point I wanted to make. Secondly, I ought to make it clear, although this is all proceeding on the basis that oil from the Bonga FPSO reached land, that's not actually accepted by the Shell defendant. That's an issue which will have to be determined, of course, but I need to make that clear lest one proceeds on the basis that that is actually accepted. And I will be taking my lords in a few moments to very important evidence about the different sources of oil pollution in the Niger Delta, because that is critically relevant to the issue which the learned judge was concerned with, which is actually, are these claimants with the same interest at all? In any event, taking 6 years, then by the 20th of December 2017, which is 6 years from the date of the spill, that would have been, we would submit the expiry of a limitation period on that basis, and that's what the learned judge and indeed this court meant by saying it was hard up against that. For reasons which become a little bit complicated, but which we can look at, because of the way that the amendments took place, the relevant date for limitation is actually not that date, not 6 years before the 20th of December 2017, it's 6 years before the 2nd of March 2020. My Lord saw something about that this morning. We can look at the judgment. That was the point, as my Lord Justice Coulson rightly identified. Because of amendments that were put forward, it was not until March 2020, when he handed down his judgment, that it could be said that there was a viable claim against Stasco, which is the, being reminded of what I do already know, which is the anchor defendant for the purposes of jurisdiction. Now, I'm sure my Lord's fully familiar with this, but just for clarity, they need to demonstrate that there was a claim against a English incorporated company served in England by the date of expiry of the limitation period. That is Stasco. There was a claim brought against RDS, which is a parent company of Shell. That was actually discontinued. So although that started the claim, that's gone. So it's all down to Stasco, and for reasons which were explained fully in the judgment of Mr. Justice Stuart-Smith in March 2020, you can't treat Stasco as actually having been sued until that later date, and that's why the limitation period actually is affected, and that's why the date is, you need to demonstrate that damage took place after the 2nd of March 2020. After 2014, 6 years before 2020. Forgive me. And if my lords would like the references to that to look later, it's explained in the March judgment, paragraphs 273 to 274, which is the authorities bundle, page 754. I'm just looking at that number again. So that's the issue about limitation. So what have the claimants or their representatives attempted to do? First, this is not necessarily in order, but just as a list, they sought to say that the damage was continuing. Actually, they said it was only in relation to nuisance, as my lords will recall. That argument of continuing nuisance was rejected by Mr. Justice Stuart-Smith and rejected by this court, indeed by my lords, Lord Justice. I've got the judgment here. By two of my
Lord Justice Coulson and Lord Justice Newey. Not necessarily in that order.
Yes, my lord, exactly. Thank you very much indeed. So that your lordships know, and your lordships probably do, there is an outstanding application for permission from that judgment to the Supreme Court. So that was the first attempt to get round the limitation period. The second really was to say that damage occurred to different claimants at different times. Now that is explained in the March judgment. It was first raised as a possibility orally on the 19th of September 2019, and your lordships see that in the chronology.
Yeah, and that's why that date is mentioned in the judgment under appeal.
Yes, well that's because that was the first time it was suggested that there could be differences. This is the business about monolithic. His lordship was absolutely right until that was said by my learned friend in argument on his feet, that the date of damage to different claimants might have been different. Everyone was proceeding, we were certainly proceeding, the judge was proceeding on the basis that it was said there was a single date of damage which applied to everyone who purported to be represented. And the significance of that, and that's set out in the judgment in March, was because it appeared that the claimants were all coastal claimants on the coast. Therefore, if an oil spill did move to the coast, it would have moved, as the learned judge said, to the coast within a relatively short period of time, and those on the coast would have been affected by it relatively soon. The idea that people could have been affected by it years later did not occur to anybody, because that didn't appear to be the case that was being put forward. Can I just take, my lords, particularly to the March judgment, at AB, Authorities Bundle, page 661, which is the page reference. So, in the judgment of Mr. Justice Stuart-Smith, he starts at paragraph 27, dealing with limitation and the claimant's approach. He notes at paragraph 28 that the evidence of the claimant's solicitor makes plain the obvious truth that proceedings were issued on the 13th of December 2017 because of the perceived risk that the primary limitation period would expire on the 20th of December 2017, 6 years after the December 2011 spill, or very soon thereafter. In one of his witness statements, Mr. Ekoratumwen asserts that the limitation period is 6 years. In another, he states that he had the impending limitation period in mind from about August 2017. If this approach be correct, then the primary limitation period for some or all of the claims would have expired shortly after the issue of the original claim form. Then he notes in paragraph 29 that before the hearing of these applications, they advanced two reasons why time should not run about the 20th of December 2011. Those were because of deliberate concealment, which was alleged, and Mr. Justice Stuart-Smith rejected that, having looked at the evidence. And then secondly, that they were the defendants were in breach of continuing duties in tort because of a failure to clean up or remediate. That's the argument that then came to this court and was rejected. But he notes in paragraph 30 that at the hearing on the 19th of September, Mr. Dunning advanced a new submission that at least some of the claimants may have suffered no actionable damage until after the 4th of April 2012, so that time would not have started running either in nuisance or in negligence until then, with the result that both the amendment of the claim form on the 4th of April 2018 and the service of the original particulars of claim on 10th of April 2018 took place within the primary limitation period as is affected those claimants. The claimants have not pleaded a case about when damage occurred, and this new submission was not even foreshadowed in their written skeleton argument for the September hearing. However, the claimants submitted that it was for the defendant to demonstrate the existence of a limitation defence, and the court shouldn't proceed on the assumption that all claims of every claimant were necessarily time-barred as of 4th of April. Well, that submission, in a sense, was accepted, because therefore, Mr. Justice Stuart-Smith said, well, if that's what you're saying now, that the date could have been later than we've been assuming, then I can't deal with it on the basis that it is necessarily time-barred now. And that, as a result, it was ordered that there should be a preliminary issue tried. Now, my lords see that at paragraph, this is important, at paragraph 276 of this judgment. Paragraphs 273, 274 state the conclusions, and I would respectfully invite my lords to have particular close attention to those paragraphs. But paragraph 276 is Mr. Justice Stuart-Smith then identified steps that need to be taken. First, the claimants must identify and plead their case on when their cause of action accrued, with a view to trying that issue as a preliminary issue, all claimants where the issue is live, and either before or at the same time as the preliminary issue, and when cause of action accrued, there should be trial of a second preliminary issue, whether the applicable period for the claimants is 6 years or 5 years. Now, both of those are
Nigerian law. Is that why?
That's not Nigerian law. There are two. We say the relevant period under Nigerian law is 5 years, and it may depend on which state you're concerned with. But that's the issue. It is a matter purely of expert evidence. There's been expert evidence. It obviously can't be decided before then. And recently, when Mrs. Justice O'Farrell made orders for what I've identified as a preliminary issue next February, it includes those two issues. And I'd just like to underline, I'm sure that my lords who are part of that Court of Appeal will recollect, my Lord Justice Green may not immediately pick it up, it's simply, although it's determined as a preliminary issue, it's actually still part of the jurisdiction challenge. And the reason it's part of the jurisdiction challenge is because we claimed that there was no, that the service out on the foreign defendant, the Nigerian defendant, SNEPCO, could not take place if there was not a proper case against the anchor defendant. And that we said that so far as, because STASCO was brought in late, there wasn't a proper claim against STASCO. That limitation point is therefore part of the jurisdiction. It doesn't matter, I think, for the purposes of this appeal, but I just didn't want it to be thought that it's, we have actually completely left the jurisdiction challenge because we haven't. So that issue as to when the damage occurred, Mrs. Justice O'Farrell made the order on the 18th of December 2020. Again, you can see that from the chronology. And no doubt I've already noted it. I want to come, for other reasons, to what Mrs. Justice O'Farrell has ordered by way of directions. But 18th of December, this is a directions order in both Jalla 1 and Jalla 2, as it's been termed. Leading to, as my lords will see, a 4-week preliminary issues trial in February 2022. So the attempt to get round the limitation period by saying damage took place at different times is now to be dealt with through the preliminary issues hearing, which will include evidence. We have strong, let me put it this way, strong reservations about the assertion as to what is said to have taken place. We don't accept that, and there will be therefore a substantial trial, including cross-examination, in particular Mr. Jalla and Mr. Chujo, who put the claim forward, and it's in that context that the date of damage pleadings were served. My lords, very, very recently served. I noted, of course, that my Lord Justice Coulson asked to see that. We have of course, no objection to that, if that's what the court would like. We will cooperate in making that available to the court. And also maps. May I just say a word about maps? My learned friend started to explain it's quite a complicated story. It is. Part of the complicated story is that maps were served back in August last year? June last year. A number of maps were served, and they were supposed to demonstrate sort of where the damage took place. What we noted was that the communities who appeared to have suffered damage, according to those maps, were all communities on the coast, essentially, on or near the coast. And of course, the date of damage argument was that communities way inland have been affected, which we dispute. And so that means that orders were made for a proper identification. When we raised the issue that the communities said to have been affected appeared from the maps served by the claimants, to be on the coast. They then said, well, actually, that may be so, but actually there are other communities with the same names which are inland. Well, there's obviously an issue which we will be seeking to explore in relation to that. Your Lordships can do nothing about it. That's just why there's a story about the maps. We will again cooperate in providing any maps that would be helpful to this court to determine the issues that it has. But I say that, what I've just said, to illustrate that it may not be possible for the court to rely completely on what they see from certain maps. So that was what I termed the second attempt. Then we have what is now the third attempt, which is effectively to say that this action was validly commenced on behalf of 27,000 odd individuals and 450 communities when the original, I think it's going to be said, when the original claim form was served, or it was issued in December 2017. Now, one of the oddities about this, and I think my lords have picked this up already, Mr. Dunning, I think, makes a virtue of this, though with respect to him, it seems to me it's actually rather a problem for him. This is not a case in which the representative claimants are saying we can't identify the class, therefore it's a good idea to have a representative action. On the contrary, they say they have identified the class in detail, and those are the two schedules attached to their particulars of claim. But it's important, I think, to note that what my learned friends now also seek to do, if my lords have their skeleton argument for this appeal, which is in the core bundle, tab 5. If my lords would go to the end of that, which is paragraph 77 to 80. They will see there's a point that hasn't actually emerged in the course of argument so far, which is that the claimants don't simply seek from your lordships, allow the appeal from Mr. Justice Stuart-Smith, which would have the effect of reversing his decision that the representative elements of the claim should be struck out. They go further than that. They want, and one can see they put it in two variants, and it doesn't perhaps matter much for these purposes which it is, though I'll draw attention to it. Paragraph 78, originally they sought an order that the representative elements of the proceedings were validly commenced as a representative action pursuant to CPR 19.61, and that representative action shall continue. Now that has a, if that were granted, it would have a limitation effect, because it would, and this is presumably their point, it would mean that this court said that these proceedings were validly commenced in December 2017. They've sought to amend it, and it's interesting to note how, in paragraph 79, they want to add in the words, alternatively, I suppose, are now validly constituted as a representative action. And the reason given for that in paragraph 80 is that if this court were to conclude that the proceedings originally were not validly commenced, but that the requirement of the same interest was satisfied once they did their, their Google thing and changed what they were claiming, then if that would then satisfy the requirement of same interest, then that would result in it now being constituted, they say, even though it might not have been at the time. And my lords can immediately see the significance, whichever variant it is, because it will affect when whether the proceedings were brought within the limitation period or not. And if they are right, that they can say that proceedings were commenced on behalf of 28,400 communities by the 23rd of December 2017, that will have a major impact, because it will mean that there are an enormous number of claims which are within the limitation period, they would say, which weren't before. And that's the significance. And whilst my learned friend puts forward additional reasons why a representative action suits their purposes, he was candid enough to accept this morning that actually limitation was the first reason, it's the first one at least that occurred to him, until he was reminded of another over lunchtime. That's obviously what is driving this. It is another attempt to get round the limitation period. And the learned judge, I think...
Well, if all this is correct, why it matters in terms of principle?
It matters in terms of principle because it becomes so important to understand what is meant by same interest and why it's not... well, I think it's obviously that because when we come to look at what same interest is, the different date of limitation in relation to different claimants is very, very significant. And my Lord, I think my Lord Justice Lewison, followed by a similar question from my Lord Justice Coulson later, was asking, well, how does this action proceed? And fundamental question is, well, how does it proceed? If it proceeds with Mr. Jalla and Mr. Chujo, let's say it goes to a trial, and it's held at the trial, yes, Bonga oil did damage land at the coast, and you're within time, because you had other land which was further away. Well, that will bind all the other people represented, and that's a critical part, as my lords know, of a representative claim. But what if it's the other way around? What if it's held that Mr. Jalla and Mr. Chujo were not in time? Their claim is then dismissed. Now, on a proper functioning of a representative order, that would mean that the claims of all the other claimants would be dismissed as well. That's one of the reasons why one can't ignore the differences, whatever my learned friend would like to suggest, the differences between the claimants. And that's not the only one, and I will come back to that. But that's why, my Lord, well, it does matter as a matter of principle, because one has to look at the practical effect of what one's concerned with. And I'll obviously come to develop that this point, but my lords will recall very well that what Mr. Justice Stuart-Smith said was whether or not these had the same interest for all practical purposes. That's a very important qualifier. We don't say, as your lordships know from our Skeleton, we don't say that means the cases have to be identical, but we do say they have to be the same for all practical purposes. And one of the practical purposes here would be, is this within or out of time? And one would expect that a representative action would take place in this way. There would be a trial, the court would reach a conclusion, and then that conclusion would bind, that's what the CPR says, would bind all the people who are represented. And indeed, it could be applied pretty much automatically. But where you have differences between the cases, how does one do that? And in a sense, my learned friend, in answering questions from my lords this morning, accepted, as I understand it, he does it in a charming way, as he always does, but he accepted that the issues which individual claimants and defendants have would still all have to be tried. I'm not sure what the mechanism for that is in a representative action, because a representative action is supposed to proceed and a decision reached which is then applied. Obviously, there are some issues, and we've seen one or two of the cases, where there may be something further to be dealt with. There may need to be an inquiry, as in the Duke of Bedford's case, there needs to be an inquiry as to how much individuals have overpaid. Well, I presume that would have been a very easy issue to determine. Once it had been determined that they shouldn't have been charged at all because of the terms on which they held their stalls, then it would be a question, no doubt, simply of identifying what they'd paid as a administrative matter, and simply saying, well, that's the amount that they should be repaid to them. Other cases, one can see similar things. Here, as I'll come to develop this, you could not apply this judgment in relation to Mr. Jalla and Mr. Chujo to all these people just in that way. It takes it completely away from the meaning of the rule and from its practical impact and effect.
You could have a judgment on scope of duty and breach of duty, be applicable across the board, wouldn't it?
But, well, you could, my lord, but that's very, but not, we would say, in a representative action as such. That would be, I go back to my Lord Justice Coulson's asking how these things can be determined. Common issues such as that most usefully would be determined either in a GLO or in, Lord Justice Green, I think, described it as bashing through the TCC. I understand entirely what he means, but sample cases and sample trials, absolutely. And that happens.
GLA would be the obvious
Yes.
way to proceed.
Except,
And then you would get the individual claimants to plead out their
Yes.
individual
yes,
losses.
and and the claimants have been asked more than once by Mr. Justice Stuart-Smith, well, is that what you're asking for? Please go away and reconstitute your action. And they don't want to do a GLO. And I strongly suspect the reason they don't want to do a GLO is they cannot then say it was constituted properly in December 2017, because you can't start a GLO without permission from the court.
So they risk limitation.
And they will lose it.
But it comes back to, and it could perhaps work both ways. Why is limitation a problem? I was struck by an observation in Mill Harbour, paragraph 30.
May I turn that over, just so I can follow what my lord's question is? I apologise.
Which is paragraph 15.
Yes, paragraph 30, my lord says.
Paragraph 30.
Yes.
And it was the observation in the middle. It's an extraordinary, cumbersome,
Yes.
and costly procedure for hundreds of claimants to be parties. In other words, to be forced to join and become litigants.
Yes.
Which is sort of it could reflect on limitation. These people didn't become parties. They sneak in, as you would put it, through a representative order. And that's how they get in.
Not trying to use the word sneak, though. I
No,
take my lord's
you're
meaning.
taking a perfectly proper point of principle, which we have to obviously grapple with.
Yeah.
But the message that is being conveyed, that in a sense the administration of justice doesn't necessarily look unkindly on people coming in, avoiding being formal parties, starting the litigation in their own names, which is an aspect of the point you're making about limitation.
Well, no, my lord, because you could do this by way of a group litigation order.
They could have done, but they didn't. They are now on the horns of a dilemma.
Well, they're not on the horn, with respect, they're
Well,
not on
perhaps
the
all right, of their own making, maybe.
completely of their own making.
But there
And we
are-
don't know why. And we do not know why they delayed. And we don't actually know, I'm sorry, I'm going to make this point, we don't really know what's driving behind it.
Let's assume it's for all the wrong reasons. They are
Yes.
now where they are.
Yes.
Is it necessarily bad policy from our perspective to sort of force them, skewer them on the horns of that dilemma?
Well,
That was really what was driving my observation. You know, what's the point of principle underlying
I see. Well,
this?
Well, let me start with this. Where we have got to in this case, but I can make the point even without this point, where we've got to in this case is now the jurisdiction of the TCC to determine these claims depends upon the claims being within time.
Yeah.
And if they're not in time, not a question of whether it's cumbersome or not, the cases cannot proceed. Whether the would-be claimants have a legitimate complaint against those they were apparently relying on to bring the claims is neither here nor there. But it is a point of principle that claims should not be brought outside the limitation period unless it's through one of the established exceptions to the limitation rule. And that's what they've tried. They've tried continuing action. They've tried deliberate concealment. They're trying different dates of damage, which we'll see where we are when this is Justice O'Farrell or whoever going to determine has dealt with it. One could not, through the device, expedient, whatever one wants to say, of simply saying, we're now going to backdate this and say this was always a representative action. Please, will you say so? So that they're within the limitation period. So, I mean, I don't shrink from saying that even large corporations are entitled not to be subjected to the cost and the time and the expense and the prejudice of bad actions. And I'm sure my lords accept that. So it's entirely legitimate for us to say that this is a point of principle. But we will bring this back.
I'm not quite sure how this works. Let us suppose that they are within the scope of the rule, but they are only trying to bring themselves within the scope of the rule in order to avoid the limitation period.
Well,
so that doesn't alter the scope of the rule.
No.
It might be a point that goes to discretion, but as Mr. Dunning says, there's no respondent's notice. So
well,
that the judge, even if it was within the rule, the judge ought to have disallowed it for one reason or another.
there's a bit more to that piece, but let me address the principal part of it. There still needs jurisdictionally to be a demonstration that they have the same interests, and obviously that's the point I'm going to deal with. And it's clear from the cases that there's been perhaps a little bit of fuzziness around the edges, or a little bit of relaxation, or as to whether, if not precisely the same interest, still it's close enough. And I will make the submission that actually the learned judge was quite right to say what you need to know is it the same interest for all practical purposes? And the practical purposes here would be, can you actually have an action which, through the representative action, will determine the rights of many other people, including limitation, including other defence. It's possible people might fall by the wayside, he said. Well, that's possibly right. That could happen, for example, if in the course of trying the action, it became apparent that there was a defence which was applicable to certain claims, but not to others. Well, then, in giving the judgment formally accepting perhaps the main claim, the judge could identify that, and therefore certain claimants might have fallen by the wayside. You know, this is a good claim, but not in relation to anyone who first suffered damage before this date or after. It's something of that sort. It's possible to do it. But when there are lots of issues of difference, and I'm going to come to that in a very few moments between the cases, so that it becomes, in our submission, impossible to say that they have the same interest. And I'll develop this, but let me just give the most basic example. Were they damaged by Bonga oil at all? That's not an academic question, as the learned judge noted. And in fact, because of this, it may be, because it'll take a few moments, it may be sensible if I take my lords now to the evidence in relation to that, because it will help, I hope, illustrate the point that I'm trying to make. My lords will recall...
But essentially, I think that your proposition is that in order to be within the scope of the rule, you've got to be able to get to a judgment which you can then apply across the class.
That's the effect and purpose, my lord, yes. The actual test is whether you have the same interest.
Yeah.
In interpreting what that means, I deduce from the cases that's what the purpose is. Yeah. Yes. I've been reminded rightly by Dr. Blake. It's the litmus test, the window, whatever one likes to say, is the representative claimants. They're the ones who are going to unlock it for everybody else, because it'll be tried in relation to them, and then, generally speaking, you can apply it across the board in relation to what's been decided against them or in their favour. But in order to understand this more, and I'm obviously making the point that this is deliberately not a GLO. They could have asked for a GLO, but they couldn't ask for it backdated. And that would not give them what they need, whatever other issues there may be. Could I...
But it could have been, and for reasons that I still don't understand, wasn't a claim brought by 27,000 scheduled claimants.
Yes. But not in December 27, because they didn't do it then.
No, but it could have been in April 2018.
Yes.
And when you say this is I think it was your third attempt to get round limitation,
Yeah.
is that the is that the period in question you say they're buying back, as it were, the period they're getting this to go back to December 2017, whereas if in fact they had commenced this as an ordinary action with 27,000 scheduled claimants in 1 and 2, that would have been in April 2018.
That looks likely. Well, as your lordship, it's a bit more complicated because they don't have a claim at all unless they've got a claim against Stasco.
Well, I was parking the Stasco thing, which I appreciate has a separate date, but just on the attempt to get round limitation, as you put it, is that for this point, that's the period we're talking about?
Well, actually, with respect, no, because you can't ignore Stasco because they haven't got a claim, not just against Stasco, but they haven't got a claim against the other defendant either, unless they've got a claim against Stasco.
Well, I get that.
I'm sure, of course, my lord does.
So that, and that's the 2020 date?
That's the 2020 date, yes. So it's actually more than 4 months. I mean,
all right.
The point would still be good as a matter of principle because limitation, you know, it's a sharp edge, but actually it's not just 4 months anyway. It goes to 2020.
But they could have all been 27,000 claimants in April 2018, and then would only, their limitation period as against Stasco, as found by the judge, would only have kicked in March 2020.
Well, because of the way that Stasco was brought in, they wouldn't have been able to bring proceedings against Stasco unless they're completely new proceedings, which is just not what happened. They brought the proceedings against Stasco. My lords will recall, it's set out in the March judgment. It's complex, but essentially they didn't initially bring a claim against Stasco at all.
Yeah.
They brought a claim against another company, wrongly, as the learned judge held. And what they then did was they tried to amend the name to turn it from what it was into Stasco. And the judge, and there's no appeal against this, the judge worked through the complicated circumstances that gives rise to demonstrate what they really needed to demonstrate, therefore, was that there was still a claim not yet expired by limitation at the date of his judgment in 2020. In other words, it moves it on those extra years so that the limitation did not, so damage was suffered after April, my math's right, April 2014.
2nd of March.
2nd of March. 2nd of March, there we are.
2014.
Got the year right, but I'm afraid I apologise.
But I'm sure it's my fault, and I'm not following. I appreciate it's towards the end of the day. But what difference does the representative action point make to that? I mean, that was the date when Stasco came in, so that was the date that was relevant. But that would be the date that was relevant if it was just Mr. Jalla and Mr. Abel in a representative action, or just Mr. Jalla and Mr. Abel full stop, wouldn't it? In other words, whether or not this is constituted as a representative action, that on that point at any rate, it doesn't make a difference, does it?
Well, look, if they'd started separate proceedings in 2012, in April 2012, then that would be the relevant date to consider. If they'd started them, purported to start them on behalf of other claimants, that would be the relevant date. That's not what they did. Because they purported to do it by way of amending existing proceedings, as the learned judge held, that it doesn't become effective because they needed permission to amend until the later date.
But if we found that this was a representative action, you say all that would be lost?
If my lords were, and there are two issues, it's only the extreme version. What my learned friend really wants is what he asks for at the end of his skeleton, which is this court to say that it was validly commenced, doesn't say in December 2017, but that must be what they mean. Not just to reverse the decision that there wasn't the same interest, but actually to determine, to declare that it was validly constituted as at that date in 2017. Now that will give them bring them all these additional claimants within the limitation, so long as, if 2017, that would be within the period, just by a few days, but it would be there. So it'd bring them all within it. That's what he's trying to achieve. so it seems to us. So it is a major, major attempt to get round the limitation period. And it's not the case that simply, well, you know, they didn't, well, I've made this point, they didn't know about the claim that they did, and they started it, they knew they were up against the limitation period. And we don't know why they didn't do what they ought to have done, because they've never chosen to explain it.
I mean, we might spend a lot of time on this, and I would like to make it clear that that's not what we're trying to do. The additional paragraphs in the skeleton were only there to clarify the position, as it were, going forward. We weren't trying to get an additional limitation benefit from those paragraphs. That was not the objective. We, as I said shortly after lunch, we accept that the relevant date is the 2nd of March 2014, because that's 6 years before the 2nd of March 2020. Or if it was 5 years, obviously it would be 5 years before. So we're not trying, whatever we put in there, we're only trying to have it regularised in the future, as it were, given the limitation decision that the judge has already made, and subject to the 5 and 6 year point. So I think Lord Goldsmith is shooting at a target which is not one which we're putting up for him.
Well, I take from that, and I'm always grateful to my own friend for his helpful interventions, I take from that he's not pursuing what he has put at the end of his skeleton argument, which is to invite this court to make an order that the claim was validly constituted as a representative action, which I interpret to mean in December 2017. He's not seeking that. That's important, because that would give rise to a need to consider discretion elements, quite apart from anything
or
else.
whatever it means, there is a concession that he's not going beyond the date that he's identified, which would then preserve your position.
Well, until my learned friend said that, of course, I wasn't aware that that's what he was going to say at all, but it's important to record it. Nonetheless, I mean, I can't get further than this, which is important. It is still a jurisdictional requirement, both for the jurisdiction of this court and for representative action, that there was at the date that this was, whatever date one's taking, not apparently the date it was commenced, that this was on behalf of claimants who had the same interest. That's the fundamental question. But I don't, despite what my learned friend has said, I mean, I don't really resolve from the fact that this still does all appear to be about limitation, because otherwise we wouldn't need to go this route through representative action. There are much more suitable routes that could have been applied, but they would not give them the same limitation position. My Lords, what I now want to turn to, I wanted to deal, to some extent I've dealt with it with the procedural background. There are a few more things I need to say. Then I need to turn to the same interest test. Then I need to deal, thirdly, with the first ground of appeal, which is the Lloyd and Google
You said you were going to show us some evidence about oil spills in the Delta.
That's what I'm going to come to. Yes, let's do it, if we may now. My Lords...
I had a heading for that about a page ago, and I crossed that out, but it was probably my fault for asking irrelevant questions. I'm sorry.
My fault for not sticking to my guns and trying to answer.
My Lords... Try and answer the court's question.
My Lord?
Never try and answer the court's question. It's most distracting.
Not advice I never go to try and put into practice. I know I'll get to if I do. My Lords, your Lordships will have seen a reference in the judgment of Mr. Justice Stuart-Smith to the evidence of Miss K.B. Otemi, and that's what I want to take my Lords to.
Right, is that in the supplemental bundle?
It's in the supplemental bundle, yes, tab 21. Now, Miss Otemi is a senior lawyer, in-house lawyer in Nigeria. One sees all that from the opening paragraphs of her witness statement. I don't need to take it to that. And she's a qualified lawyer, Nigerian bar, which is at paragraph 7. What she then does, starting at paragraph 9, is give an overview of the security and pollution issues affecting the Niger Delta. Now, I'm certainly not going to read all of this aloud. My Lords may find it helpful at some stage to glance through more of it. But the critical points I can show are these. Firstly, in paragraph 9, she makes the point that it's highly implausible, this is about 3 lines from the end, that contamination was caused by Bonga oil at the dates that are being suggested. Principally, what she then does is demonstrate what the sources of oil pollution in the Niger Delta are. In paragraph 15, she starts to talk about the criminal activities which result in oil pollution. Paragraph 17, she starts to focus on the different forms: oil theft, which are pilfering and illegal local refining, and large-scale illegal bunkering. And when one gets to paragraph 18, my lords will begin to see the relevance of that, because she starts to talk about illegal artisanal refineries. It's a lovely word to describe what is in fact just a criminal activity. But what they do is they cook the crude, they steal the crude, they tap into the pipelines, and they take the crude, and then they cook it. The point is they can't refine it fully, and as she says, 55% of the crude goes to waste, most of which is dumped into the nearby water or into a shallow pit. So one of the principal causes of pollution is illegal refining, which leads to oil waste being dumped. As to how widespread this is, in paragraph 19, she deals with the evidence about that. One sees about 4 or 5 lines down that just about 3/4 of the spillages within the regions are caused by third-party interference, which includes sabotage, vandalism, and crude oil theft. And the number of those is indicated a bit by paragraph 20, that 2,000 suspects were arrested on account of their involvement in that. 4,000 refineries, 30,000 drums of stolen crude were destroyed. If my lords will then go a bit more specific to the area, to paragraph 24, she identifies a government agency which produces reports. And in paragraph 24.2, 24.1, she says that the number of spills across all Niger Delta states is just under 10,000, and this is in the period 2013 to 2016. And in relation to the Delta and Bayelsa states, just under 5,000 different oil spills. Paragraph 24.
What are we to do with this?
Right.
Mr. Dunning says, look at what's in the claimant's pleading and assume that it's true. On the basis of what the claimant pleads, is there a common interest? You are saying, no, look at, I don't know what you'd call it, background, what the defendants might say, what the issues are that are likely to arise in the case. So what approach should we take to the material which we are either entitled to or bound to consider in deciding whether or not there is the same interest?
But we invite the court to take the same approach that the learned judge was, taking a realistic approach to what the cases are.
In other words, look at it in the round.
In the round, certainly.
This is not a question of asking a question analogous to whether the particular claim disclosed the cause of action.
No. It's looking to see whether, for practical purposes, that these claimants have the same interest. And when one sees, I mean, this is just on one point, when one sees that the people purportedly to be represented include people spread over an area of Belgium, as my board used that example before, that's exactly the area that we're talking about, said to have been caused damage over a number of years, can one realistically say that these are people who have the same interest? So that, and one of the consequences will be, could one apply a judgment to those people? Because ultimately, having a representative action is intended to be a way, as the authorities show, of efficiently determining causes of action and claims.
Can we decide that? Can we even apply common sense? I mean, do we know?
Do we know what, my lord?
Anything really about it? We understand, we can see from the maps what the geographical scope is. We could assume that there are alternative forms of pollution, but how can we form any form of view? how can we come to any conclusion, even to form a rounded view?
Well, my lords can, because my lords can look realistically at what is taking place and what is being said. I mean, my lords talk about the pleadings. There are no pleadings by the individual claimants other than Mr. Jalla and Mr. Chujo saying why someone who now says he suffered damage hundreds of miles away, which could only have reached, and therefore it said, I suffered this damage at a later date. What is going to happen if the action proceeds on that basis? How will the court be able to apply the judgment to those people? Simply not conceivable. And
But I think Mr. Dunning accepts that the same factual inquiry will have to take place as would have taken place where there are 28,000 claimants, that you will need to know whether somebody with some land 100 miles up the delta suffered damage in 2017 as a result of the oil spill from Bonga in 2011. And one can see that there may be evidential difficulties, but at this stage, what can we say except that these points are likely to be hotly contested?
well, to some extent, they're being ordered to be tried, like the limitation
Yeah.
point. They can say it's not demonstrated that these claimants have the same interest.
Right. Well,
Not a common issue. That's not the test.
now I follow.
Whether it's the same interest.
So the claimants say, we've all been damaged by oil from Bonga, and you say, no, you haven't. There are lots of other sources from which you might have been damaged by oil. Now, we can't resolve that issue, obviously.
No, my lords can't resolve that issue now. That will have to be resolved at some point if the actions proceed. But what my lords can say, particularly looking at the authorities, which we'll do probably now tomorrow, is that this does not achieve at all the objectives of a representative action in relation to these two claimants. All that it will achieve will be to do something in relation to the limitation period. That's not a justifiable reason for allowing this to continue, for allowing it's not ever started. Of course, it was not started.
Yeah.
My Lord Justice Coulson noted, if one looks at the claim form, this was never started as a representative action. One sees that from tab 10. It's not until tab 11 that
It
it's
says and
first.
others on the claim form, but we don't know who they are.
Well,
Original
only in April. Only in the following April.
The December one says and others, but it doesn't say.
I
who
think
they
it
are.
does, my Lord.
Yes, it does.
Oh.
It is always the under.
Yes. All right, I'm corrected. I apologise, my Lord. But we do say, and the authorities make this clear, it's right that the court should look at likely defences,
Yeah.
not try them, but should look at likely defences in determining whether this particular form of case management, if to some extent that's what it is appropriate.
And that's part of the flexibility, is it?
Well, there's a limit to the flexibility because, and I'll take what we had from the Chancellor in Google was to say take the statement, despite the fact there have been some historical twists and turns, take the statement as it came from this court in Emerald, and from the test itself, which is the statutory test under CPR 19.6, that there needs to be the same interest. And I'm saying there may be a little bit of wiggle room around what is meant by same, but not that turns it into something which says, if it's convenient, it makes it helpful to try some common issues, then it becomes appropriate as a representative action. That's why the learned judge was right to say the mere fact that there are common issues doesn't make it appropriate for representative action.
Not least because there are other ways of dealing with that.
Not least because there are other ways of dealing with that. Well, yes. There are these days, I mean, some of the earlier cases, it may have been more difficult, but now we know that there are, so certainly no justification for stretching the bounds of what is a jurisdictional test.
Yeah. All right. Well, is that a convenient moment?
My Lord, yes.
10:30 tomorrow.